Namaste, good morning. Welcome to this 112th episode of AAA Weekly Webinar Series. As usual, we are starting on time, and today is the subject which is a mix of insolvency and bankruptcy and the Companies Act. The demand from our audience was that what are the various methods of dissolving a company or exiting a business when the company was set up and there is no business in the company now. So what are the ways that we can get rid of all the compliances required under the Companies Act? So we would discuss like the options of dissolving a company, or even to some extent removal of name of the company from the register of companies maintained by the Registrar of Companies under the Companies Act. What are the advantages and disadvantages of each method of dissolving a company? So when we start with this, the first thing which is most popular is liquidation under the Insolvency and Bankruptcy Code 2016. However, there is no direct route to liquidation. The direct route to liquidation is only voluntary liquidation, but the direct route to liquidation, if the liabilities are more and the assets are less, then it has to go through corporate insolvency resolution process. Once the resolution process fails, then only the company can go for liquidation under IBC. So then the second method is, in case the directors can give an undertaking that each and every liability of the company would be paid or provided for, and they are able to justify that the assets of the company are more than the liabilities of the company, then based on the declaration and based on the resolutions in the board of directors, they can apply for voluntary liquidation, and an insolvency professional as registered with IBBI can be appointed as voluntary liquidator. Now, the one is the liquidation post failure of resolution process. Again, the insolvency professional will be appointed. Then in the voluntary liquidation, again, insolvency professional would be appointed. See, in case we see the Companies Act, there was provisions of voluntary winding up also under the Companies Act 2013, and those were sections 304 to section 323 of the Companies Act 2013. But these sections were omitted. In fact, part 2 of the Companies Act were totally omitted with effect from 1st December 2016, when this insolvency law was made effective. Then then there is another option which is called the removal of name of the company from the register of companies maintained by the Registrar of Companies. So there are section 248 to section 253 of the Companies Act, where the name of the companies can be removed from the register of companies maintained, and then thereafter there would not be any requirement of kind of complying with the regular compliances under the Companies Act. Then there is a possibility of winding up by the tribunal, winding up by NCLT under section 271 to section 323 of the Companies Act. And we will also understand today what kind of situations where the NCLT can pass an order for winding up or liquidation. However, in this case also, based on the amendment effective 1st December 2016, only an insolvency professional can be appointed as the liquidator. So this is a direct route to liquidation. And in this case, the companies are not supposed to go through the resolution process. So So therefore, this is one option which is available for complete dissolution of the company under Section 271 of the Companies Act. Then there is another provision under the Companies Act which is called a summary procedure for winding up of the companies, that is under Section 361 of the Companies Act, but that is applicable to very small companies, and we will also discuss this in this scenario. So we have discussed like the liquidation under the IBC. We have also discussed voluntary liquidation under the IBC. So today we are not uh, kind of discussing the most of the provisions under the IBC, because probably my audience knows most of it. So Ankit, would you like to say something, because since you joined a little late? So today we are discussing primarily the provisions of the Companies Act for dissolving a company or for removing the company name of the company from the register of companies maintained by ROC.
So, like by personal experience, I would say that we normally go by the strike off route, but the strike off route is can have its own issues. Now, the strike off route has certain preconditions, and I believe that we can always talk about those at length. But those conditions have to be met. Similarly, for voluntary winding up under IBC, there are some preconditions. Then it comes to, what is the process cost, how much cost is the company willing to incur, what kind of assets are still there in the company. There is also a little bit of income tax implication. In case you dissolve a company which already has assets in it, there might be some kind of an income tax benefit as compared to somebody, giving dividend and then finishing off a company which is not having any asset at all. So that is also something that comes into play here, that which choice is a better choice for the promoters, for the company. Then there can be pending litigations, there can be other issues which are stopping the liquidation. Recently, we came across a situation where a voluntary winding up mandate came to us, but we could not take it forward because FIMA compliances were not in place for the investment that was made in the company by a foreign investor. So now that has gone back to that process. So these are some checks that are required for making sure that the professional is not taking more scope of work on his hand as compared to what he should be.
So Ankit, what you are talking about striking off, that is exactly we also would like to discuss. That is called removal of name of a company from the register of companies maintained under the MCA with the registrar of companies. That is Section 248 of the Companies Act 2013. So this section gives a power to the power of the registrar to remove the name of the company from the register of companies. Now, it is the power with the registrar only, and I believe the tribunal, NCLT, is not involved in this process. So this process is considered to be the easiest process when the company fails to commence its business within 1 year of its incorporation, or the company is not carrying on any business or operations for a period of two immediately preceding financial years, and has not made any application within such period for obtaining the status of a dormant company. So there is another status, Ankit, that I would like to say. There is a process called dormant company. I mean, we will discuss the dormant company also. So the dormant company also has very, very few compliances to be done. So then the registrar suo motu can send a notice to all the directors and to the company of his intention to remove the names of the companies from the register of companies, and requesting them to send their representations along with the copies of the relevant documents, if any, within a period of 30 days. If you recall, Ankit, during this Modi government, at one point of time, probably the registrar of companies announced that they have removed about 1 lakh companies from the register of companies, those companies who were not doing business, not doing compliances, and also they were so they're completely kind of like not the objective of their being in existence was not seen. So therefore, the companies were in fact removed from the register of companies. Now, this this section says that the company also, one is the registrar, and the company also can apply for removal of its name through the directors. Now, what is required? One, that the company should extinguish all its liabilities. Therefore, there should not be any liability in the financial statements of the company. Then there should be a special resolution or consent of 75% members in terms of paid up share capital. Then the company can file an application in the prescribed manner before the registrar for removal of the name. That's what is called striking of the name. And based on all these applications, the registrar will actually issue a public notice. I mean, normally the registrar issues a public notice on a duration when it's a composite notice for various companies that the registrar is issuing. So therefore, this particular act is also considered to be simpler in case the company is able to extinguish all its liabilities and the decision of the shareholder is to dissolve the company, so they can take the route of striking of the name of the company or removal of the name of the company from the register of companies maintained by ROC. However, in case this particular section is not applicable to various scenarios. One, that if a company is regulated under a special act, then the approval of that regulatory body would also be required for such striking off. And the see, like, why it is required, why people are doing this, because see, the company doesn't want to bear the burden of annual compliances. Therefore, this kind of actions are normally taken by the various promoters. The uh, the other important part is the uh, no objection certificate that we've already said. No objection certificate is required from the appropriate regulatory authority, and the indemnity bond will be required to be executed by all directors. And the statement of accounts of the company, not later than 30 days before the date of application, because in case you are filing application today, so you need to attach the statement of accounts of the company not older than 30 days preceding the date of filing of the application, and that too certified by a chartered accountant. That is the main condition. So no objection certificate from the regulatory authority, a resolution duly passed in the meeting of the members of the company, and uh, the extinguishment of all the liabilities of the company, and also the company would be required to ensure all requisite statutory compliances up to the date of application. However, this is not required. There is no adjudication required by NCLT. So, but then the only issue is that at registrar at times may take a longer period. A registrar at times may take a longer period because of the overburden on the registrar. So the only disadvantage is that one, that you have to show that uh, all the liabilities are extinguished. You have to show that you have paid all your taxes. You have to show that you have met all your statutory compliances and obligations. And then, see, but then this method is also not applicable to kind of listed companies or the company which has actually got delisted from the stock exchange sometime. It is also not applicable to in case the company is declared as vanishing company. So it is also not applicable to those companies where some inspection or investigation has been ordered under any sections, or any prosecution have been started against the company or its promoters. So, and such inspection or such investigations are pending, then the companies where the notices under section 206 or 207 have been issued by the registrar or the inspector, and some kind of inspection has started, where the prosecution of an offense is pending in the court, the application for compounding of the application offenses is pending before the court, where there are some public deposits which are in default, and there are some charges pending before their satisfaction. So all these cases, the uh, striking off or removal of the name from the register of registrar, that is not possible. So there are exceptions, but this is more simpler method. So this is, like, as I said, this is simple. a quick completion in the registrar in case the registrar takes action, give a public notice at a shorter duration, then it actually can become a kind of advantage. Yes, the disadvantage is only waiting period, and also this becomes sometimes very riskier for the directors, because the directors are supposed to give a indemnity bond for any future liability. Indemnity bond for any future liability. So in case any future liability comes, the directors are not absolved from their responsibilities. The directors will have to indemnify that loss, may it be a government department or any other creditor. So Ankit, anything that you would like to understand about this, or any questions on this?
So here we have a question from Neeraj Ji. Neeraj Ji says that his company was struck off 5 years ago, and he says that is there still any compliance required? So that's his question. And there I again think that after the company is struck off after an application filed by the directors, the only reason why it can be unstruck is in case there is some resurfacement of any litigation that was still there, in case the strike off was not legal. Only then the strike off can be restored. Now the strike off also does not uh, so even if it was, so his comment now is that it was struck off by ROC, it was not struck off by him. So there again, the liability towards any person to whom that company owes any money, any income tax department liabilities, any GST department liabilities can still come over this company. Also in this case, in case this company is indeed having some assets, then it will be in the interest of directors to making it unstruck. So that's also a case here where it is suo moto struck off by ROC.
Yes, yes.
Then there's a question uh, Mr. Manduk. He says that up to what time ROC can initiate inquiry after filing application for strike off?
No, it is not a question of filing application. It is a question of when the name is striked off, and the 20-year is the period up to which any kind of investigation or any kind of inspection can be ordered, or any kind of liability can be surfaced. Once the period of 20-year is lapsed, thereafter, I don't think there would be any liability which can come and that is surfaced on any of the directors.
So then the next question is from Sandeep Goyalji. He says, when the company can file voluntary liquidation under Section 272 of Companies Act, or they are now required to file voluntary liquidation under Section 58 of IBC 2016. So that's an interesting question. We can answer that. Then, of course, there is what recourse. There's an anonymous question which says what recourse can be taken against the directors of a struck-off company if a person has a decree in its favor. Indemnity bond will make them liable to honor the said decree. But what forum can we need? Will they need to approach? This is the question.
Now, one question is like the voluntary winding up is the better way forward to dissolve a company. But the only condition is that you have assets or means to pay off all the liabilities. I'm not saying pay off all the equity also, but the liabilities. In case you have an equity of 1 crore and you are not able to pay even 1 rupee out of that 1 crore, still you can go for voluntary winding up. And however, all these statutory liabilities actually will continue. But voluntary winding up is such a process which is much more secure than striking of the name. Because the striking of the name, the due diligence is not complete. In the case of voluntary winding up, the public notice is given, the claims are invited, and once the claims are invited, that means once the company is dissolved, it will not be like no liability will resurface. The directors are safe, the company is safe. So the voluntary winding up is the in thing after this promulgation of IBC from 1st of December 2016. This is the only method that the people are going forward. Striking off is not being preferred only because of this reason that the liabilities of the directors will continue. So what is the other part of the question, Ankit?
So the other part of the question was the second question that came in was about what recourse can be taken against the directors of a struck-off company.
So the
That was
first
the
thing, you
second
file
question.
an application before NCLT that I have a liability and this company has been fraudulently struck off, or it has been this information has not been uh, given to the registrar by the director. So this company's name may be it should be replaced in the register of companies. Once the name is registered, once the name is
Yeah,
re-entered in,
hmm.
re-entered into the register of companies, then thereafter you have to see whether you are struck by the limitation law, or then you can take any kind of actions for the recovery of your amount. Maybe you can go to commercial court, or maybe you can go to the insolvency court, depending upon the kind of liability that you have.
Then a question from Mr. Hari Prasad, which says, what is the difference among the strike off by ROC, strike off on the request of directors, and voluntary liquidations? He kind of wants to understand that if the strike off is done by ROC versus in case strike off is done on the request of the directors, does it make any specific difference?
No, it doesn't make any difference. Like one, first of all, we will differentiate between the two. Strike off voluntarily suo motu by ROC based on the non-compliances, based on the non-filing, when the ROC takes some kind of bulk action. So that is something which is not considered to be very, very favorable because see, ultimately the directors will become liable whenever somebody uh, goes to any court. So the name will be re-entered into the register of companies, and any kind of action can be taken. So that is not closure of the liabilities. Now, in case the application is made, that also is the same thing. In case the application is made in the case of strike off, no claims are being sought. That means all the liabilities are based on the declaration of the directors and the resolutions passed in the meeting of members. So, in case there is no such liability is uh, declared, or a kind of
I think it can make a difference only to the extent that if maybe if a director is wanting to do some activity through another company through his in his individual name, and in case he goes for a KYC, then somebody who understands or does a due diligence on his name might find out that okay, there were these two companies, three companies which were struck off because of non-compliance versus these two, three companies which were struck off on application of the director. I believe that is the only difference that I can think of between striking off by the ROC and striking off on the request of the directors. That strike off by ROC will always be a negative, mark on the director's record,
yeah, yes, yes.
right? So that I believe is a very significant difference. Of course, the voluntary liquidation difference that you shared is very, very material. That in case of strike off, it kind of, the sword can keep hanging on somebody's throat for 20 years, that anything can happen. Somebody will have to be very sure that he has not done anything and anything at all in that company, that something can come out to still go for strike off. But for voluntary liquidation, as you said, is a more complete process which kind of addresses all issues.
Now I will move on to Ankit, another summary procedure for winding up of companies under Section 361 of the Companies Act 2013. So here this summary procedure provides the method for winding up. This is other than winding up in the situation of an inability to pay debt. So in fact, the company's winding up rules were made in 2020, and that has been notified also, and there is a complete detailed procedure. See, this is the process which actually has to be run by the regional director of the Ministry of Corporate Affairs, who oversees the region where the company is located, and subject to some kind of conditions that the company has to meet, the regional director, based on a petition filed by the company, and also in case the company meets the specified thresholds, then he can appoint a liquidator for liquidating the assets of the company. And after the liquidation is over, the regional director is empowered to pass an order of dissolution. However, there are some difficulties that this process and this winding up rules, and under Section 361 of the Companies Act, this is only applicable if the company should have assets of book value not exceeding 1 crore of rupees. So it should be based on the audited financial statements that the company has taken deposits, does not have outstanding deposits exceeding 25 lakhs of rupees. The company does not have total outstanding loan, including secured loan exceeding 50 lakhs of rupees. The company has a turnover up to 50 crores of rupees. The company has paid up capital not exceeding 1 crore of rupees. So these are the threshold specified criterias, and if all you see, or like if these are met, like in case their deposits are outstanding which is more than 25 lakhs, that means not covered. If the loans, secured loans are outstanding which is more than 50 lakhs, the section 361 is not applicable. If the company has a turnover of, as per the latest balance sheet, which is more than 50 crores, 361 cannot be invoked. And in case the company has paid up capital of exceeding 1 crore, it cannot be. Similarly, assets cannot be more than 1 crore. So if these threshold limits are possible, then the company can file a petition before the regional director along with the statement of fare, and regional director definitely would assess whether the threshold of the commencing summary liquidation has been met, and then he can pass an order appointing an official liquidator of the company, and the official liquidator will dispose of the assets of the company within 60 days as prescribed in the winding up rules, and submit a final report to the regional director, who will receive the report, and finally company would be dissolved. So this is something which is legally validated. So this is a legal kind of validation, and there is some assessment by the regional director. It is slightly better than striking of the name, because in this case, the name of the company will be dissolved. In the case of striking off or removal of the name, the company is not dissolved. And then it is the like kind of assets and liabilities can be managed very well. So the only thing is that the regional directors are not really having a kind of streamlined process. So it may be difficult, it may be a kind of very like bureaucratic approach may be there. The documentation and the compliances, the requirements of the regional directors may be very time consuming. So that is the only disadvantage according to me under section 361 of the Companies Act. That is only applicable to smaller companies. See, but the most important part that we are going to discuss today is that we have seen recently that some companies are making application to NCLT under section 271 of the Companies Act. So when we see section 271 of the Companies Act, it also talks about the winding up petition, which can be filed by any kind of stakeholder, any contributory, or even the registrar of companies. So this kind of petition is possible to be filed before the NCLT under the Companies Act, under section 271. Now, although the scope has actually become narrower, I have also seen some of the applications have been rejected by NCLT, saying that we have a better forum, we have a better remedy wherever the company feels that the company is not able to pay its debt. Rather than invoking section 271, it should actually go for the normal winding up or an application under section 10. So the company itself, so some of the applications are also getting accepted. However, in this section 271, one amendment was made with effect from 1st of December 2016, when this IBC, along with the IBC, so it's a part of the Insolvency and Bankruptcy Code, the amendment under section 271, where it is mentioned that in case any liquidator is supposed to be appointed under section 271 of the Companies Act, then it would be an insolvency professional as defined under the code. So insolvency professional can only be appointed under this, and that would be appointed by NCLT. NCLAT has also said in a couple of companies that such applications it should not be accepted when we better have. But recently we have seen a couple of companies have got this order where the insolvency professionals have been appointed without going through the CIRP process directly on an application by the company. Now, in this case, once the liquidator is appointed, the entire supervision will be done by the NCLT, and these winding up procedures will be conducted as per the liquidation process regulations and as per the IBC. Now, the 271, in fact, also allows the registrar of companies to invoke Section 271 and pass an order for winding up of the company and appoint an insolvency professional as liquidator in this case. So in case the company is kind of functioning against the interest of the sovereignty of the and integrity of India, that is where the registrar or any agency can also initiate the insolvency. When failure to file financial statements, that also can be a reason to kind of file the insolvency or pass an order for liquidation. And just and equitable ground, NCLT is of the opinion that it is just and equitable for the company to be wound up. So the process that has been like kind of according to our experience is one, the petition should be accepted by NCLT and the liquidator is appointed, and the liquidator would constitute a winding up committee and submit a report within 60 days. Then NCLT may fix a timeline in which the liquidation shall be completed. Then the final dissolution will also happen. So the advantages of this particular dissolution is it's a legal closure. It's a legal dissolution. So it actually provides a kind of structured and legally recognized process of closing a company. So all the statutory requirements are met. After this kind of dissolution, the directors and other stakeholders are free from all kind of debts, and then it would be again avoiding the legal actions against the company after that. Comparatively, it is also considered to be low cost, because if a company, if the stakeholders, if the promoters, directors, if they are convinced that they have to just liquidate the company, sell the assets and distribute it, so they can definitely avoid this corporate insolvency resolution process, and simply they can see that yes, the company will go for the liquidation, the NCLT will pass an order, and the liquidator would be appointed. So it's a comparatively low cost, and the time also would be like the time consumption will also be less. Because in the case of normal liquidation, where the assets are less than the liabilities, or the directors are not able to give any kind of undertaking that they will be able to pay all the debts of the company, then this method is actually suitable, provided NCLT considers it just and equitable. Then, like in case, in all these scenarios, when the dissolution happens, it is actually the advantage is to the creditors, because the cost of liquidation is less, the legal struggle is less. So simple sale and whatever is according to the Companies Act, that would be distributed. At times, it may be time consuming. At times, the NCLT may not be convinced because of the normal process of CIRP and liquidation. So they may not be convinced. So therefore, this is something which is considered to be not really very popular. But yes, recently we have seen few orders where the liquidators have been appointed by the NCLT. So Ankit, I think at this moment we can take some question, or I can even say that I have with me a judgment in the case of Rajesh Agarwal versus Premier Protein Limited, and that's a judgment dated 27th of February 2023 from NCL 80 Principal Bench, New Delhi. Now, in this case, again, the application was filed by one Rajesh Agarwal, and for under section 271E and 272, seeking the winding up of the Premier Protein. The company was in fact incorporated in 1986, and it went to BIFR, and then like it was also listed on Bombay Stock Exchange. The financial health was deteriorating, and in 2019, significant short-term borrowing, the liabilities, in fact, the turnover was only 3 lakhs of rupees, accumulated losses were 24 crores of rupees. Given the lack of any prospects, any revival possibilities, the promoter Rajesh Agarwal directly applied for winding up his company before the NCLT. No, in this case, the NCLT rejected this application. And now let us see what NCLAT says. Now, NCLAT says that this Premier Protein Limited has been experiencing financial distress for a prolonged period and have been even declared sick under BIFR. The financial health is not seen good, and there is a lot of losses and there is no turnover. The long-term liabilities instability is seen, which is very high. And further, the NCLT emphasized the discretionary nature of the powers under Section 271, which requires a thorough evaluation of whether the circumstances justify winding up on the equitable ground. So the application was made on equitable ground. The equitable ground was no financial strength, no possibilities of revival. It is simply like we need just winding up without going to the CIRP. So, however, there was one kind of flaw that they could not implead one operation secured creditor, that is Cargill India Private Limited. So, based on this, the NCLT said that this is not really kind of just and equitable, because one of the important secured creditor was not impleaded in this case. So therefore, the NCLT rejected the application. And now NCLAT also said that this discretionary jurisdiction with NCLT definitely can be exercised by the NCLT benches. The appellant, the Rajesh Agarwal, failed to convince just and equitable grounds for winding up. So therefore, the NCLAT also supported the view of NCLT and also said that in view of alternative remedies available under IBC, therefore, the IBC is more structured and it actually also addresses any kind of potential revival. So, however, the procedural lapse is not really significant, but the legal remedies available other than this winding up, revival remedies available under the IBC, that should have been tried first. So that's what was discussed in this case. However, in many cases, the orders are also being passed. I think we can take some questions now.
So basically, question from Mr. Raj Kumar. He says directors are also absolved from statutory liability in Section 271 cases.
Yes, I say yes, because 271 is also a process to be run through NCLT. The liquidator will have to be appointed, and under Section 271, according to me, the process of inviting claims also would be done. So therefore, it is a process where the CIRP is kind of avoided and direct liquidation can be opted for. In case a good case can be made, so that actually is possible.
Then,
also will be absorbed.
Then the next question is how IP is appointed in Section 271 cases.
The NCLT will appoint the insolvency professional, maybe from the panel or maybe on the recommendations of the applicant.
Whether all guarantors will be relieved when creditors have settled loans through IBC proceedings. Guarantors cannot be relieved.
The
From
guarantors
guarantors
cannot be
continue to guarantors will have their own process.
like a kind of again a separate liability. With the dissolution of the company, the guarantors will be
Will
responsible.
continue to be liable. Yeah. Then we have Mr. S.D. Gupta. There is a provision for early dissolution and CD-wide regulation of the CD by Regulation 14 of IBBI liquidation process. Kindly elaborate on the regulation. So
Which
early dissolution is that when you say that, okay, the assets are already, I think section 14 of IBBI liquidation process, early dissolution must be with respect to filing for a dissolution after understanding the assets are not there during liquidation process.
Yes, like that is something which is always available when the liquidation order is passed and the liquidator has assessed the assets and liabilities. And if the liquidator see that there is no asset, then the liquidator immediately file an application for early dissolution of the company. This is what he's talking about.
So Gulshan ji is saying that the minimum threshold for section 7, 8 or 10 application is 1 crore. And he says that therefore it will be an alternative recourse under section 271 for those people to go in who have a default of less than that 1 crore.
No, but for voluntary liquidation, there is no such limit of 1 crore. So we are
Voluntary
only considering
liquidation, but
voluntary
voluntary
liquidation and winding up under section 271.
liquidation cannot happen for an insolvent company, right?
Yeah, voluntary liquidation cannot happen. Yes, yes.
Insolvent
So
companies
this
who
is
don't have a
interesting.
debt which is more than 1 crore.
So what exactly Rajesh Agarwal did, because he was not able to go for voluntary liquidation and he was not able to go for CIRP and therefore he tried 271. However, like he could not plead another very important secured creditor, so that was a kind of procedural lapse. But recently, I have seen 2, 3 orders where under section 271, direct liquidator has been appointed by NCLT. So this is a new thing which is coming up where the companies uh, which would like to dissolve and they are not able to go through the voluntary. So this is the only way, and they don't want to go through the striking of the name because that's very, very risky for even 20 years. So therefore, this is method which is legal.
Yeah. Then we have a question from Naveen Bhatia ji. He says, how under which provision which is now applicable for winding or default of debt, which was earlier of section 433 of the Companies Act 1956. 433 of
Uh, Insolvency Act, and it was omitted. But now what we have is 271. The second is that we have this 361 for a smaller company, and then we have the another concept of dormant company. I will also come to dormant company, voluntary winding up and the winding up under the IBC. So there are 5 options that we have discussed already. One is the winding up, liquidation under the IBC, voluntary liquidation under IBC, then 361 of the Companies Act for smaller companies, then the 271 of the Companies Act, and then this is then the striking of the name like 248, and then we would be discussing the dormant companies.
Lalit Maheshwari ji is asking, can a new company be formed by the same promoters when earlier company was struck off by ROC under section 248A? When a company is struck off by ROC by ROC under 248A, there is a possibility that the director is also listed in the disqualified directors. That is the only issue that can come between the new company being formed. However, we have seen that the strike off of the company continues and the directors are able to establish in some court, some jurisdiction, they are able to say that we were not responsible for the striking off of the company and their DIN is revived or their disqualification is removed. There, the directors can then continue to be directors of other companies. Even if a director is disqualified under Companies Act, the disqualification stays for 3 years, if I'm not wrong. So after 3 years, he can still make a company because he will again regain the eligibility to be a director.
Right.
This is my understanding of
Right.
this. Then Naveen Bhatia ji is saying that for default of any, I think we've already taken care of this. Then we have a question from Sandeep from Mr. Sai Karunakar. He says, what is the role of liquidator after the sale of the company as a going concern during liquidation with regard to the restoration procedures of the company by the new management, like induction of new directors, capital reduction, new share capital allotment, etc.? What are the provisions that speak about this in the Companies Act or IBC? So liquidation as a going
No,
concern is akin to almost a resolution plan. So like a resolution plan talks about a IMD implementation and monitoring committee. Similarly, the plan which is approved by the NCLT for liquidation of the company as a going concern would also have certain provisions, or should normally have certain provisions, to allow for all these transition of the control of the company, going to the directors of the company, new directors of the company. So I believe the liquidator will get its role from that document, from that plan. Any
let
other view
me
from you?
no, let me add a little. So when the company is sold as a going concern, the liquidator still continues. The liquidation process will be closed once the everything is completed. Now, what is supposed to be completed by the liquidator? The company is sold as a going concern in a liquidation process. The letter of intent is issued. Now, the money is received in the liquidation account of the liquidator, and that money also can be disbursed. However, when the company was being sold as a going concern, the document would say that the liquidator will hand over the company to the buyer. The liquidator will, based on the order of NCLT, will appoint the directors of the buyer on the company. The liquidator will extinguish the capital of the company. The liquidator will issue the new capital to the buyers. So all this will be done by the liquidator. Like in case there are books of accounts which are pending, the liquidator will complete the books of account. Liquidator will draw financial statements. Liquidator will get the financial statements audited. Liquidator will file income tax returns. Liquidator will file ROC returns, and then the liquidator will hand over everything to the buyer. And then after that, in case there is any exclusion from sale of the company as a going concern, normally whenever we sell the company as a going concern, the any proceeds of the avoidance transaction is kept by the directors. The directors doesn't sell that particular part to the buyer. So the liquidator will continuously proceed and continuously follow up with those avoidance transactions application. And if there are some other assets, maybe which are kept outside from the sale of the company as a going concern, the liquidator will dispose of that. Again, the liquidator will distribute all the proceeds which may come from the avoidance transaction, which may come from the sale of an RRA, which may come from the sale of all those assets which are kept outside the sale as a going concern. After that, the liquidator will make an application to NCLT for closure of the liquidation process. Then the liquidator will stop working as liquidator once the liquidation process is closed by NCL.
Right. Then there is a question from Mr. Manduk. He says, can a company file application for strike off when there is only share capital and no other liability? How share capital will be distributed among shareholders after strike off proceedings are completed? So in a strike off proceeding, what happens is that you have to, shut down the bank account and also have a proof of closure of bank account. So any liabilities that are payable, and in case there are no liabilities, it's only share capital, then what happens is that you pay that money to the share capital or the shareholders, and then file for the strike off. This is what we have been doing practically, where the shareholders are still, the money is still available to pay to the shareholders.
Yes, I believe you are right. But then in some cases, I have seen that whatever money is due to shareholders, the similar money is given as advance to those shareholders, and then the strike of application is filed. And so there is no liability in the balance sheet. There is no asset, and the asset matches with the share capital. So that is where I think it is acceptable to ROC, and most of the people are doing this only.
Vipul Dubey saying that in case where the liquidator wants to file and dissolve the company under liquidation, but one of the immovable properties is still there, but could not be liquidated. Kindly discussed all such possible scenarios. So, in wherever a property is there still with the company, it will not make sense to dissolve the company, because if you do go for dissolution, you will never be able to realize that asset. So that's why, many liquidation cases are pending with liquidators, where there's some kind of litigation pending, some kind of property which is not getting disposed. So those liquidations are then the longer liquidation processes that continue for a while.
There is one option, Ankit, in case the creditors also agree, the creditors can get this property transferred against their claim and the
Mhm.
company can be liquidated.
Yeah, that option is available in
That
liquidation
option is
regulation.
available as per the liquidation process regulations.
So Vipulji can always explore in case the creditors are okay with transfer of this property to the creditor's name.
Yes.
So I think that's about it. One last question from Sandeep ji. What is the responsibility of provisional liquidator appointed under Section 272 of Companies Act when he comes to know that all the assets of the CD are already sold and up-to-date balance sheet is not filed at ROC, and as per ROC report bench mentions the assets and fees of the liquidator is fixed as a percentage of the asset. On further inquiry, it has come to the notice that all the residence of promoters, directors is already sold and current residence is not known. There is no office of the CD and the register office. I think Sandeep ji, many of the people who are listening to us would relate to what you are experiencing here, that the liquidation is somehow, taken forward and the liquidator is appointed from the panel maintained by NCLT and the liquidator finds that he's in a spot. There is no fees, but there is a lot of work. So I believe you are in a similar spot with this kind of a company. The only option is to complete the process ASAP and then file for dissolution. This is what we have been doing in similar cases.
So this is something that as a lawyer, when somebody is supposed to do something pro bono, so this is also
This is pro
actually
bono.
can be pro bono. Although at one point of time that we think that the IBBA was thinking some kind of remuneration to such liquidators or such RPs, but I don't think there is anything has been finalized so far.
Yeah. Lalit Maheshwari is saying when the company is struck off by ROC and information is sent to bank also, can signatory of bank account operate account? So it is illegal then to strike off. Before strike off, you have to give a declaration that the account is closed. You also have to submit the closure certificates, and the company is maintaining, let's say, two, three accounts, and it chooses to keep maintaining an account, and then continue to, file the application for strike off. So that would be illegal. And I'm not sure if ROC sends any information to banks that the company is struck off or something like that. I don't think it happens like that.
No, I don't think the ROC actually will send this information to our to banks
But
or will
like,
go and
yeah.
verify it from the financial intelligence unit. But then in case somebody is having a bank account and still get the name striked off, it is not really legal. So we have 5 minutes, so we would like to discuss the section 455, which defines about the process of dormant company.
Let's go with
So
that.
so we actually see that if a company is incorporated, maybe for a future project to be taken, and that time has not come, and the directors and the promoters they are not interested in continuing with the compliance, so they can apply for declaring this company as dormant, and at a later stage they can even get it active. Also, where the company is only holding an asset or only holding a trademark or any kind of intellectual property right, and there is no significant accounting transactions, and such a company may make an application, or any other company which is inactive may make an application to the registrar. There is a method prescribed, and that the company may be given a status of a dormant company. Now, see, like in case we say that the company is an inactive company, so that also there is a definition of the inactive company means the company which has not been carrying on any business or operation, or has not made any significant accounting transactions during the last 2 financial years, or has not filed financial statements and annual returns during the last 2 financial years. The registrar also can suo motu declare the status of the company as a dormant company. Now, the significant accounting transactions mean like the it means transactions like there are some transactions which are not considered as significant, like the payment of fee to the registrar, the payment which is required to be made for under any law, allotment of shares to fulfill any requirement under the act, payment for maintenance of the records of the company or its office. So all these payments are not considered significant payment, and in case there are any payments which are more than this, then the company may not be considered as dormant company. So the registrar on an application shall allow the status of a dormant company to the applicant and issue a certificate also in this respect. And the registrar, in fact, is maintaining a register of dormant companies. So that is where what is prescribed under this section 455. And so the registrar, even suo moto, can give a status of a dormant company, the company which has not filed the financial statements or annual returns for the 2 financial years. First the notice would be given, and then the status would be changed. So the minimum number of directors must be there. The documents for paying of annual fee must be filed. So in case the dormant companies are also supposed to comply with some minimum compliances. So in case those minimum compliances are also not done, then the registrar can automatically strike the nominee, strike of the name of that company from the register of companies maintained by it. So that is what is a dormant company. So I think we still have a couple of minutes, so we can take some questions in case we have. So otherwise, in case anyone would like to speak, we can give some opportunity to anyone who actually can raise hand for speaking and for adding something to this, because see, like any recent scheme by ROC, which is called kind of fast track scheme. If anyone has having any knowledge of any recent fast track scheme, because see, what I could see was a very, very old fast track scheme. I don't think that is applicable and that is available today. But I think since there is no question, so we can wind up the episode today.
So one or two questions that I can still ask. So Sivaji is asking, once the CD is dissolved by NCLT, liquidator's role is completed. Who will follow up for Section 66 case after dissolution of CD?
So
So
I think the regulations provide very clearly that in case you file an application for dissolution of the company, you also have to, in the application, you have to also mention that who will follow up and who will pursue the avoidance transaction application, and whatever proceeds will come, how that would be distributed, and who will make all the expenditures. So this has to be decided within the stakeholders consultation committee meeting, that who will handle these avoidance transactions after the dissolution of the company is ordered. So maybe creditor or maybe a law firm who has already been paid, and an agreement with the law firm can be given to the NCLT, and the law firm would be under obligation that whatever proceeds will come, that will come in the bank account of one of the creditor, and then the bank account will be distributed amongst the creditors in some manner. So that kind of agreement is also possible with the law firm, with a lawyer, so that the dissolution processes can be completed.
Mayank Singhalji is asking that as per the rule, after the appointment, the liquidator has to file a list of contributories, but without a proper information provided by promoter, how is it possible to file Win 17 with the list of contributories and form committee to liquidate?
I think we need to understand like what kind of liquidation it is. Is it under section 271? So we need to understand. So I could only find under
If
section
public information can
271.
be used, yeah, public information can also be used for completing this process, whatever is available. Please appraise the liability under GST post dissolution, if any, under GST income tax, and the directors are even liable thereafter. So directors will continue to be liable for operations of the company while they were directors. That's part of all GST and income tax laws, in my opinion. Further, in case of private limited companies, where directors can be held responsible for not, being not paying, not allowing the company to pay, or coming in between the recovery process, the directors even become personally liable. So those things are there.
These are the provisions which are not very successfully implemented by the income tax department, because there are three exceptions. Like the directors would be personally responsible for making payment of all income tax liabilities of the company in case 1, 2, 3, in case they knowingly did something, or like they know. So all these conditions are difficult for the income tax department to prove. So therefore, not many cases where the companies, unless the directors have already undergoing some cases of fraud which they have conducted on the company, then they are made personally responsible for the income tax dues also.
Yeah. So great. I think we have answered many questions today, more than 20 questions. And Anandji is asking your comment on the recent statement by FM on recoveries through IBC, but I believe we will leave it for some other time. And thank you so much for such an interactive session today and for all the questions that our participants put forward to us. Thank you so much.
Thank you very much. This is our way of learning. Thank you.
Thank you.